Hello. Well, my paper is kind of focusing on different questions because I will talk about recognition of domestic worker rights in Argentina, looking at the institutional process involved in this recognition. For us, domestic workers included care workers and cleaning workers. We don't have the distinction in the regulation specifically. And like I said, my focus is on the institutional process of the recognition of domestic workers' rights initiated in Argentina in 2009, when the international movement for domestic workers' rights reached their momentum with the creation of a specific ILO convention for domestic work. This process can be analyzed by differentiating two moments involving various institutions in the country. On the one hand, the making law process involving National Congress, and on the other hand, the implementation through compliance and enforcement mechanism involving tax agency, which is in charge of collect social contributions, and the implementation through disputed resolution mechanism involving a special administrative jurisdiction called Domestic Work Tribunal. The question that interested me is how different state institutions, almost at the same time, respond to the demand for the recognition of domestic workers' rights. Three institutional strategies will be analyzed here: Congress strategies, National Tax Agency strategies, and Tribunal of Domestic Work at Buenos Aires. In 2013, after 3 years of discussion, the National Congress approved a new special regime for domestic work. Since then, the National Tax Agency developed different strategies to promote compliance and to enforce the legislation. And during the last 5 years, the Administrative Tribunal for Domestic Workers has introduced some innovation on the procedures and of the resolution of labor dispute. The various strategies developed by these three institutions seem to depend on the way these institutions define domestic work as a special labor relationship. In all three cases, state agents, legislators, tax agency, or domestic work tribunal agents have to face the same delay faced by ILO representative and expert during the standard setting process. This dilemma was presented by Adele Blackett as the choice between two opposite ways to consider domestic work as a job like any other or as a job like no other. If domestic work is considered as a job like any other, general employment regime can or must apply to this kind of work. At the contrary, if domestic work is considered a job like no other, legislation must include special provision for this activity. In that case, a special labor regime may be the most common type of regulation. However, as Blackett highlighted in her research concerning the ILO Convention 189, the two notions play a role in the standard setting process. In Argentina's case, analyzing the strategies developed by this institution, the tension between the two notions remains. However, a new crucial notion plays an important role in the lawmaking process and during the process of implementation of the new law, which is the definition of the employer as an employer of like no other. Domestic workers' employers is another worker, is a family, or even another woman, worker woman. The analysis of the institutional strategies shows that the two definitions of domestic work are constantly in tension with the definition of the employer. For nearly 60 years, the Decree Law 326/56, which established a special labor regime for domestic work, was the main legislation regulating this sector in Argentina. Although this was the first special legal framework for this sector as a whole, it was highly restrictive in comparison to the general employment regime for two reasons: the provisions and the scope. Certain provisions like paid vacations, sick leave, and severance pay were included, but the length and the amount applicable for domestic workers were substantially lower than what applied for employees. For example, the severance pay was half the amount applicable under general regime. This regime only applied to workers working at least 4 hours, 4 days a week for the same employer, while in the 50s these were standard higher terms. When temporary work became increasingly common, the definition of domestic work excluded nearly half of all domestic workers from the scope of the law. These regimes also established an administrative tribunal exclusive for domestic work, labor dispute. This specific administrative jurisdiction, which answered to the Ministry of Labor, was shaped following the model of other administrative jurisdictions entrusted with resolving individual conflict among employees, functioning like a first instance court. In 60 years, this regime had only few small amendments until domestic work organization put the necessity of a legal reform of the center of the public debate. By mid-2000, in Latin America, domestic workers' organizations were actively engaged in regulatory reforms at international, regional, and national level. When Convention 189 was starting to take shape, the Latin American and Caribbean Confederation of Domestic Workers Organization played an important role in supporting the international standard setting initiative, and after its adoption, they actively promote its ratification. At the regional level, with the support of Mercosur Feminist Association, Domestic Workers Organization presented a proposal to the Mercosur Parliament for harmonized legislation. In 2009, the Mercosur Parliament approved a specific regime with the aim of establishing certain minimum requirements for protection of domestic workers. However, Common Market Council, Mercosur's highest decision-making body, never enacted this regime. Nevertheless, in 2012, the Council made a resolution to establish the obligation of all state members to ratify Convention 189. At the national level, the activism for the recognition of domestic workers' rights resulted in 13 draft bills presented to the Congress between 2009 and 2011. The aim of the new law passed in 2013 was to ensure that domestic workers had the same guaranteed rights as other employees under the general employment regime, and to expand the scope of the law to include all domestic workers, given that the new law acknowledged anyone performing at least 1 hour a week for one employer as a domestic worker. Because domestic work was considered a job like any other, paid vacation, sick leaves, and severance pay, special leaves such as maternity leave, marriage leave, study leave, hazard insurance, working time were aligned with this general employment regime. Also, because domestic work was conceived as a job like no other, some specific provisions were included, like a shorter provision period, 30 days for leaving domestic work and 50 days for leave out, against 90 days for the employees in the general regime. However, because the lawmakers focused on the employer limitation to pay social contribution, they decided to maintain the special social security regime established in 1999, in which domestic workers working less than 60 hours per week for the same employer must complete their contribution for having access to social benefits. Also, they decided to enroll domestic workers in a non-contributory regime as family allowance. When the new law was approved in 2013, 84% of domestic workers were informal workers. Thus, the National Tax Agency developed different strategies. Some of them were the same strategies used to address all kinds of employers, but others represent a renewal of strategies used to employers who are difficult to inspect. To promote compliance, the National Tax Agency incorporated the IT technology to simplify the registration of employers and domestic workers. Since 2013, workers for registration at the payment of the employer contribution were made through the website of National Tax Agency and also using home banking. And 6 months ago, the agency introduced an app which allows employers to pay contribution and domestic workers to control its payment. Also, the app reminds employers the deadline for paying contribution and regularly sends information about domestic workers' rights, such as wage and working conditions. Also, National Tax Agency established tax exemption for employers who register their domestic workers. National Tax Agency also established an ex officio formalization procedures aligned with the legislation of Social Security fraud approved in 1970s and amended in 2004. This legislation established a formula for estimating Social Security debts of employers in textile industry and construction sector. Following that model, in 2013, the minimum domestic work indicator was established. This indicator was based in gross annual income and personal assets, especially real estate. In cases in which the gross annual income and the value of the home exceed the minimum established by the indicator, the state could assume that there was a domestic worker at home who had not been enrolled. In such cases, the public treasury sent a warning to the taxpayer, given them the deadline to formalize the presumed employee. If the taxpayer did not enroll a domestic worker within the same period, the public treasurer proceeded to collect the Social Security contributions and taxes, and also impose fines. This measure, which became known as presumption of domestic worker, was controversial but effective, at least for the first year. In 2016, considering that the indicators were insufficient to presume the existence of an informal domestic worker, the measure was repealed. However, it was established 3 months ago. Concerning dispute resolution mechanism, the Administrative Tribunal for Domestic Workers at Buenos Aires is organized by a procedure that includes a mandatory mediation process and binding arbitration. However, the Domestic Work Tribunal also accepts voluntary agreement between the parties in conflict. Both parties, accompanied by their lawyer, must provide a writing agreement detailing the duration of the labor relation, the reason for termination, the wage paid, and the amount offered as severance payment. Any conciliatory agreement must be approved by the Domestic Work Tribunal before it becomes binding. As an internal rule, it has established that only the agreement acknowledged 70% of item claim could be approved. Most agreements between domestic workers and employers were reached during the first stage or even before the formal process began. The expected duration of the arbitration encouraged early resolution because neither of the parties is interested in a long litigation process of 2 years or more. Domestic workers prefer agreement instead of arbitration for 3 main reasons. First, although most decisions are in their favor, the weight is often difficult to manage, consider that all labor disputes take place once the labor contract has already been terminated. And domestic workers do not qualify for unemployment benefits. Severance pay is crucial for the period in which they are looking for another job. Second, agreements are easier for domestic worker tribunal to enforce than arbitration. That is because for an agreement to be approved, employers must complete the payment of the amount established in the agreement. What is the case? The same claim cannot be made during another arbitration process. Third, it is sometimes difficult for domestic workers to prove the existence of the labor relationship because they do not have credible witness or witness at all. In that case, because the outcome of the arbitration is uncertain, lawyers often advise them to sign an agreement instead of continuing with the arbitration process. For employers, the main reason for signing an early agreement is principally monetary. In order for the domestic work tribunal to approve an agreement, employer must pay at least 70% of the amount detailed in the claim. However, this 70% does not include items that need to be proved, such as extra hour or fine for employers who hire domestic workers informally. Because the voluntary agreements are signed before the formal procedures start, and because most conciliatory agreements are signed before the disputed parties present their evidence, the Domestic Work Tribunal does not have the fact to establish if extra hours claimed were effectively work or whether the labor relation was formal or informal. For that reason, the fine for hiring domestic workers in an informal arrangement does not apply to settlements. In the arbitration process, if the labor relationship proved to be informal, the severance pay is double. The third actor participating in the dispute resolution process, the state, via domestic work tribunal, is also interested in avoiding lengthy process because of its lack of human resources. State agencies then actively promote early agreement. Thus, for different reasons, these three actors involved in the process all favor voluntary or conciliatory agreement in early stages of the arbitration process. As a result, most domestic workers involved in a labor dispute get settlements in which they do not receive all they are due under the law. Looking at these three institutions, it seems that the state engaged differently in the recognition of domestic workers' rights during the last 5 years. While important regulatory amendments were included in 2013 law to expand labor rights for domestic workers, an innovative enforcement mechanism have been implemented for the formalization of domestic workers' labor relationship, the mechanism for labor dispute resolution seems to moving in the opposite direction, encouraging minimal compensation to quick settlement, meaning reducing domestic workers' rights to a convenient amount of money that employer can afford. Merci.